Before a single sentence is finished in this courtroom, the tension is already thick. This isn't just about sentencing. It's about time, consequences, and whether the system shows mercy when the calendar turns to the holidays. On one side, a defendant hoping for delay. On the other, a judge bound by agreements already signed and deadlines already missed. What you're about to see is a plea bargain playing out in real time, where every word matters and every pause carries weight. The question is simple but heavy. Once you've agreed to the terms, can the court afford to bend, or does accountability come first? Stay with us, because the decisions made here will follow this defendant for nearly a decade.
To be sentenced, if that's what the court pleases. Mr. Alvarez and his family has asked me if it would be possible any way he could get past the holidays, or at least through some of them.
No.
Very well, Your Honor.
All right. So you entered a plea in cause number 2023 CR 8797W. The court will follow your agreement. And Mr. Alvarez, I want you to know that I don't take any of this lightly, as far as when there's a request for people to wait to be sentenced, maybe after holidays or something or some other date. But you entered a plea to be sentenced on October 5th. And now a month has passed. So that is why we're going to go forward with sentencing, okay? So I wanted you to know that I internalized your counsel's request, and I actually really strongly consider it, okay? All right. So in cause number 2023 CR 8797W, the court is going to follow your agreement, sentence you to 9 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 8796W and (2022) CR 7605. Take in consideration the following NITMAG numbers: 704498, 704692, 727545. And I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
This moment is critical. The judge isn't just announcing a sentence. She's locking in the consequences of a plea bargain. By accepting this agreement, the defendant receives a defined sentence, but in exchange, he gives up something massive: the right to appeal. That means this 9-year prison term is final, barring extremely rare circumstances. The concurrent sentences may sound like relief, but make no mistake, 9 years is 9 years. And when the court explains firearm and ammunition restrictions, it underscores that this conviction doesn't stop at prison walls. So ask yourself, is certainty worth giving up your chance to challenge the outcome later?
Because it's a felony conviction, you're not allowed to own, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And cause number 2023 CR 8796W. The court will follow your agreement. Okay. Court will sentence you to 9 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 8797W. Take in consideration NITMAG number 704498, 704692, 727545. And this will also run concurrent with 2022 CR 7605. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, so have you all discussed the motion to revoke?
I was gonna learn current. Yes, you're just gonna feature. We did, but maybe we did. Maybe we didn't, yeah. I thought we were just. Major dismissing.
All right, the court is calling 2022 CR 7605. Mr. Alvarez, I'm gonna show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First amended motion to enter adjudication of guilt and revoke community supervision, and second amended motion to enter adjudication of guilt and revoke community supervision. And counsel, could you do a trial court certification?
I will, Judge.
Okay. It's on the wall. Did you review those documents with your attorney? Did you understand them?
Yes, sir.
Are you the same Mark Anthony Tino Alvarez who was placed on deferred adjudication in 2022 CR 7605 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on November 2nd, 2022 for a period of 3 years? Is that you?
Yes, sir.
All right, state.
This is on the first amended, Judge. This is violated condition number 4. In Bexar County, Texas, the defendant, Mark Anthony Tino Alvarez, did then and there fail to report to the supervision officer as directed for the months of April and May 2023 in violation of condition number 4.
How do you plead to that? True or not true?
And Your Honor, we waive the other violations alleged in the motions.
Any objections to the waivers?
No, sir, Your Honor.
Okay. Did you understand by pleading? That's okay.
I apologize.
No, that's fine. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, sir.
Here's where things escalate. Deferred adjudication is often a second chance. No final conviction if the rules are followed. But failing to report even something that may sound minor can unravel everything. By pleading true to the violation, the defendant opens the door for the judge to revoke supervision entirely and impose a full prison sentence. The court carefully confirms that he understands the risk, up to 10 years. This is the system drawing a hard line. So, let us know in the comments, should technical violations carry consequences this severe, or is this the cost of ignoring court orders?
Court will find violation of condition number 4 true. Is there an agreement?
There is, Your Honor. We're asking that you grant the motion and the MTR can concurrent with the other costs, Judge.
And how much time are you asking?
9 years, Judge.
All right. Mr. Alvarez, are you asking the court to follow that agreement?
Yes, sir.
Are you waiving your right to appeal?
Yes, sir.
All right. Then the court will find violation of condition number 4 true. And did you understand the court will find violation of condition number 4 true. The court will grant the motion, find you guilty, sentence you to 9 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 8796W and 2023 CR 8797W. Just one moment. Court will give you credit for any time served. And was the fee for the lab ever paid, the $228?
I don't know the answer to that, Your Honor.
Not sure, Judge.
Okay. Probation?
Yes, sir.
And cause number 2022 CR 7605, was the $228 for laboratory testing paid?
That is still outstanding.
All right, so there's going to be restitution of $228 to the lab for testing. and I'll have that run concurrent with your sentence.
Thank you, Your Honor.
You're welcome. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because it is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Alvarez, I realize that 9 years is a long time. Honestly, any time that you do in custody, that's a long time. Even if it's one day, it's a day out of your life. So you're going to have to start making better decisions. Otherwise, when you come back, you're going to get to the point where you're in the habitual status. And your counsel will tell you when you're marked as a habitual in a majority of felony cases, your minimum is going to be 25 years. And that's a super long time. Okay.
Yes, Your Honor.
All right. Good luck to you.
Thank you.
All right.
Have
You're welcome.
issues?
Yes. Thank you. Excuse me. We can't have that.
In the end, the courtroom delivers its final word: 9 years in prison, all cases running concurrently, restitution ordered, and a clear warning about the future. The judge's message is unmistakable. Continued poor decisions don't just add time, they can multiply it, turning years into decades under habitual offender status. This case is a powerful reminder that plea agreements, probation terms, and deadlines are not suggestions, they're obligations. If you found this case as intense as we did, hit that like button, share your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.